Okay, good morning, Monica. Today we have finals.
Good morning.
I'm going to start with my Q&A.
Okay.
And so let me give you some proper names, Monica. We have Letty, Rob, and Jake. Okay, Monica?
Okay.
And Q&A. Final exam, 160. And it starts in the middle. Any questions, Monica?
No. No
Okay.
questions.
I'm going to go ahead and mute you then, okay?
Okay.
Okay, so this is going to be your final, number 160 Q&A for 5 minutes. Letty, Rob, and Jake. Just a minute, just got a message from the dean's office. Sorry, Monica.
No worries.
Okay, here we go, and it starts in the middle. Did you receive a letter of resignation from him?
Yes,
Did you give it to Letty once you received it?
I don't recall. I may not have received a letter.
So let's go back to the original question. How is it you ended up taking Letty and talking to her about the retaliation and complaints?
I had received notice of Rob's resignation, and I'm not sure in what form. And I went to her office to talk about his resignation.
Did she ask you to come to the office to talk about it?
I may have asked her if I could. I don't recall.
You don't remember one way or the other,
No.
but you do recall going to her office and discussing it.
Yes.
Was anyone else present when the two of you spoke together?
No.
You mentioned that Letty was keeping you advised of the conversations she had with Rob about his use of sick leave during the time he was absent, correct?
Yes. She would respond to my concerns.
In other words, right around that time, you began to notice that he was absent a bit.
Yes.
Did you talk to Rob about it?
No.
Why did you go to Letty instead of talking to Rob and seeing if there was a problem and how he was doing?
It was an unusual thing.
How many days in a row did he miss?
He was out for a week.
How many sick days do you get a year there?
12 days a year.
Had Rob used up his 12 days before he took that week off?
No.
You weren't aware that he had gone over his sick leave, correct?
Correct.
Did he discuss with you the reason he was taking sick leave?
No.
What was so unusual about taking a week of sick leave?
I'm not sure that I was aware of why he was out sick.
Would Rob call in to let someone know each day that he wouldn't be in?
Yes, he would call in and let Jake know.
Would Jake then report to you or Letty that Rob was out sick?
Yes.
Can you tell me why it bothered you that he was calling in sick?
It just felt very open-ended to me, and I wasn't sure if I should contact him during this absence.
Was there one period he was out a week, or were these 5 days scattered over a period of time?
It was one solid week.
Now, you were still meeting with Rob on a weekly basis, correct?
We met as often as needed.
You no longer met on a weekly basis as required?
The last 2 months of Rob's employment, our meetings were less frequent.
Isn't it true that you had stopped holding regular weekly meetings with Rob for a period of at least 6 months before he left?
I am sure we met weekly, but not always as a formal thing.
At some point during the week, you might be in the same location with him within the office.
Yes, we often discussed issues relating to his work.
I guess the question in my mind then is that when he's out for a week, why didn't you just walk into his office and ask him how he was doing?
He wasn't in his office. He was out, and I didn't know when he was coming back.
How many days had Rob been out sick when you went to talk to Letty about him?
A week, as I recall.
Then after you talked to Letty about him, he came back to work?
Yes.
Do you remember how soon after your talk with Letty it was that he returned to work?
It was within a day or two.
Did you tell Letty that you were concerned about Rob?
Yes, I did.
Did you express the nature of your concern to her?
Yes.
What did you say to Letty about your concern for Rob?
That I felt it was something other than his being ill.
How did Letty respond when you told her that?
She said that Rob was having a difficult time and to try to accommodate his time off.
How long after that was it that he resigned?
Less than a month.
Was Letty's only comment to you that Rob was having a difficult time?
Yes.
Did she give you any information as to the nature of the difficulty he was having?
No, she didn't.
Did she tell you how it was that she had arrived at the opinion that Rob was having a difficult time?
Yes. She said that she was in contact with him.
Was it only one conversation you had with Letty about Rob and his use of sick leave?
Yes.
What did she tell you about her? And then on the second 160 Q&A, you have AFS, Ziploc, Deputy Garcia, Peoples 2, Paraphernalia. Monica, any questions on anything there?
No, no questions.
Okay. And so this is going to be 160 number 2. I'm going to mute you, Monica, for 5 minutes, okay? And it does start in the middle. I know, am I trying to see if I can get farther? Let's see. Sorry, do you want me to move it on this side? Maybe, yeah, perfect. Here we go, 160 number 2. Can you go ahead and place the gun back in the large envelope? I think all the magazines went back in the separate envelope.
Okay.
Thank you. After you observed all the items that we've just been talking about and looking at, what did you do?
We recovered them.
And did you have the opportunity at some point to discuss the items that you found in the house with the defendant?
Yes.
First of all, did you ask him about the gun?
Yes.
After, when you asked him about the gun, were you already in receipt of the information from AFS that the gun had been reported stolen?
Yes.
What did he tell you about the gun?
He said that he had bought it from someone on the street for $50.
Did he have any opinion about whether it had been stolen or not?
When I asked him, what he thought about it, since he bought it on the street for $50, he said, yeah, he figured it was stolen.
Did you also ask him about the marijuana that you observed on the table in the room?
Yes.
And I guess all the other items that were associated with it? What did he say about that?
He just said he was selling a little marijuana on the side to make some extra money.
Now, at any point, did the defendant direct you to any other narcotic items that you hadn't already found?
Yes.
How did that happen?
While talking to him, we asked if he had, I believe we asked if he had a car. He said there was a car right out in front of the lock, parked along the curb, and somehow we figured that was his car, or he told us. I don't remember exactly. As we were talking to him, he said there was more marijuana in the vehicle, and he gave us permission to go in the vehicle and get it.
Did you find anything in there?
Yes.
What did you find inside the car?
It was a plastic bag. It was sitting on the back seat of the vehicle covered by a jacket. And in that plastic bag was 2 Ziploc baggies containing marijuana and then just a large chunk of marijuana.
Okay, Deputy Garcia, I'm showing you what we've marked as Peoples 2 for identification. Do you recognize what's in that photograph?
Yes, I do.
What are we looking at here?
It's a white plastic bag, and in that bag are 2 clear plastic Ziploc baggies containing marijuana, and within the white bag is also a large chunk of marijuana.
Is this the baggie and contents that you found in the defendant's car on January 14th?
Yes,
How can we know that it's the same items?
I believe my initials are on the baggies. Just barely see them.
Do you do that as a matter of course?
Yes,
Is that to keep track of items that otherwise look like other items?
correct.
Now, I think we dealt with this probably for the most part earlier when we were talking about your training and experience. But have you had specific experience in determining in the course of an investigation whether a particular group of narcotics is possessed for purposes of mail versus personal or sale versus personal use?
Yes,
And do you have an opinion in this case as to whether the marijuana that you found in the defendant's house and in his car was possessed for purposes of sale versus personal use?
it's definitely for sales.
What makes you say that?
Several things. For one, it's obviously a large amount of marijuana, obviously more than the normal person would ingest in a day or two. The defendant did not appear to be under the influence of marijuana that day. I didn't find any marijuana smoking paraphernalia in his vehicle or in his house. All the marijuana within his house was individually packaged for easy street sales. They were all the packages were about the same weight. He had the scale, which is used to weigh out the marijuana. If he was using it for personal use, it wouldn't matter how much it weighed, each baggie anyways. He had a large amount of money sitting with the marijuana in small denominations, which is common, when you sell with the money. He also had another large chunk of marijuana which he hadn't bagged up yet in his vehicle, and simply his statements.
If I told you to assume for purposes of a hypothetical, if I told you that you observed all of the things that you told us you observed, and you knew that there was heavy foot and car traffic into the location, okay, and I'm now going to my 140s. On your 140 number 1, you have Jim, and that's it. Any questions, Monica?
No, no questions.
Okay, you don't need time?
No, I'm good today.
Okay, Monica. This is going to be then 140 Q&A final, number 1, and it starts in the middle. Did you see any of the young men at that time?
Yes, sir.
Were they there at the same time Jim got in front of the garage door?
Yes.
Were the young men in or out of the car?
Outside of their car.
Could you describe what the 2 men were wearing?
One of them was dressed in all white, but I don't remember what the other one was wearing.
Did you see the 2 of them exit the vehicle?
No.
Do you recall which way the vehicle was parked?
It was facing toward the apartment.
Do you recall how close the front of the vehicle was to the small fence that closes off the little yard in the apartment complex?
It was within a couple of feet.
Do you remember how close the vehicle was parked in relation to the garage door?
It was parked about even with the walkway.
Could you overhear anything that was said?
No, sir.
What's the next thing you noticed that Jim came up to the apartment? When?
No, sir.
There wasn't anything unusual about what you saw there?
No, sir. Not at that time.
Did you see Jim get stuck or hit with anything when he was first down there?
No, sir.
Were either of the young men closer to Jim than the other?
No, sir.
Were there any young ladies in the area?
Yes, sir.
How many young ladies did you see there at the time?
Only 2, I believe.
And no other young men besides the two we've already mentioned.
Not at that point.
Now, if I understand you right, the next thing that happened is Jim came back up into the apartment.
No, sir. There were two guys that came down from the apartment and then Jim came back.
Do you know who these young men were?
One of them was a tenant at the complex.
And what did those two men do when they came down from the apartment?
They were out in the area with the other four people.
And they had just walked down to the downstairs apartment?
Yes, sir.
Now, if I understand you right, you've got four young men down in the parking area and two young ladies. Is that correct?
Yes, sir.
And at that point, Jim left the area.
Yes, sir.
The next time you saw Jim was when he came back in the front door of the apartment.
Yes, sir.
Were you still in the same location on the couch?
Yes. I was facing outside looking through the window.
Do you remember where Jim's wife was at that time?
She was sitting in a chair in the living room.
Had either of you been drinking that day?
No, sir.
Did you drink frequently with Jim and his wife?
No.
Did you drink with Jim once in a while?
Yes, sir.
Had you been taking any medication that day?
No, sir.
You were not under the influence of any medication or alcohol or drugs?
No, I was not.
During that day, I think this was Tuesday or so, had you gone to work?
No, I was job hunting at that time.
Were you unusually tired that day for any reason?
No, sir.
Had you eaten at Jim's residence that day?
Yes, sir.
Were you living there with Jim and his wife at that time?
I was visiting.
Had you stayed overnight the night before?
Yes.
How long had you been staying overnight there?
I had been there for 2 weeks.
During the day of the assault, did you see Jim drinking?
Yes, sir.
Do you remember what you saw him drinking that day?
He was drinking vodka.
Did you see him drinking out of the bottle that day?
No, sir. He was drinking out of a glass.
When Jim was down in the driveway and the four young men were there, do you have an opinion as to his state of sobriety at that time?
For Jim, he was pretty sober.
By that, do you mean you have seen him on occasions when he was very drunk?
Jim was a regular drinker.
Do you mean that he drank every day?
No, that's not what.
And so I said stuck. Okay, don't change it, stuck. And then you have your 140 number 2 proper names: Dr. Moore, Dr. Priest, Jackson Avenue, Manning's Mortuary, and Manning. Any questions, Monica, on anything there?
No, no questions.
Okay, this is going to be then 140 number 2 for 5 minutes, and it does start in the middle. Q&A final. Has Dr. Moore given you any particular restrictions? By that, I mean, did he ever express that there were particular things he did not want you to perform?
Correct. He did.
Can you tell me what actions he's restricted you from?
He told me to continue taking the treatments, and I take heat treatment and everything.
At his office you're talking about?
Correct. I take them at his office.
But I'm talking about, has he given you any specific activities that he does not want you to do?
No work.
No work?
No work.
You told me earlier that you haven't been working. Is that correct?
I haven't been working.
Are you looking for employment of any description?
No, I'm not looking.
What do you do during the day generally?
What do I do?
Correct. What do you do?
I exercise myself. I occasionally walk.
Do Do you watch TV at all?
Correct. I sit down and I look at television.
I'm just attempting to get an idea. I realize that you have a lot of free time on your hands. Therefore, I'm attempting to get an idea of what you do to pass the hours. Do you participate in hobbies?
No, I only hobby if I have is that I got to church and serve the Lord, the Spirit, and the truth. That's my hobby.
Mr. Priest, have you ever filed lawsuits previous to this one?
No, absolutely, positively not.
This is the first lawsuit you filed?
Correct. That's correct.
Have you ever made any claims for insurance where a lawsuit wasn't filed?
No, I have not.
In other words, if you were in an automobile accident?
No, I don't know. I can't answer that question.
Have you ever been in any automobile wrecks?
No,
Do you own an automobile?
no, I don't own one.
Have you ever owned an automobile?
I have through the years, but never an automobile wreck.
Have you ever been riding in the car with anybody when they had a car wreck?
No, I've been fortunate.
You're a lucky fellow.
Thank goodness for that, I say.
Do you rent or do you own your residence?
I rent my residence.
And who is your landlord?
I rent from the gentleman from the funeral parlor.
Which funeral parlor are you talking about, sir?
I think they're on Jackson Avenue. I think it's in the 1800 block of Jackson.
Do you know the name of it?
Manning's Mortuary.
Are you saying Manning?
Yes, Manning.
This address looks like the same address as your residence where you live.
It's exactly the same place.
Do you live there?
Correct, sir.
At the mortuary?
Yes, at the mortuary.
Is it a two-story building or how is it designed, sir?
Two-story building.
Is your residence on the top or the bottom?
I reside on the sofa.
How much rent does he charge you for that privilege?
Alexander charges me $180 a month.
Do you receive any kind of social security or such?
Yes, sir, I do.
Can you tell me if it's social security or disability, or do you know?
Social Security, and that's all.
How much a month do you get?
I get about $400 a month.
Do you get any other kind, or do you have any other kind of income?
Yes, I've got another kind of income. I get city retirement.
You worked for the city.
Certainly, I certainly did.
For how long were you employed by the city?
I worked for them for 30 years.
Can you tell me what your responsibilities were for the city?
Previously, I used to be a caretaker.
What did you take care of then?
Dead, not living.
Dead individuals?
You had to be dead to get taken care of.
Would you go to the hospital and pick these bodies up?
Oh no. You see, I was employed in the autopsy morgue. I transported bodies up from murder scenes and so on. I picked them up and took them to the lab and prepared them for autopsy. I undressed them, put their clothing in containers for evidence. Then I showered them for the coroner to do an autopsy so I could.
Okay, so we're gonna, Alexander, just Alexander, okay? We'll go on to your 140 multis. Any questions, Monica?
No, no questions.
Okay. Okay, I'll start giving you some words. Monica. Got on your 140 multi-number line. That's okay. I'll mute it till she comes back. Okay, you have Mrs. Delaney, defendant Matthew Rayburn. Matthew Rayburn. One more time, Mrs. Delaney, defendant Matthew Rayburn. Matthew Rayburn, defendant Rayburn, defendant Proctor. Ellingham, People versus Ortiz, Mr. Phillips. And so it's all colloquy, so you identify us as we speak. Okay, every time we speak. So you have Mrs. Delaney, Mr. Phillips, the court. Any questions, Monica, before we make our announcements?
No.
Okay, so I'm going to mute you now. This is going to be 140, number 1. And I am Mrs. Delaney.
The witness. The court.
Mrs. Delaney.
The witness. The court.
And so it does start with Mr. Oh, it says Phillips.
Oh, you're Mr. Phillips.
Sorry, did I do it wrong? Oh, yeah. Yeah. So Monica, if you just want to switch the names real quickly, Mrs. Delaney is,
No, there's I know.
so Mr. Phillips, is that Michelle?
You're Mr. Phillips.
I'm who?
Mr. Phillips.
Oh, because mine's, then do we have that? I said Mrs. Delaney. Just a minute, Monica, sorry.
Okay.
And according to this, I'm Mr. Phillips.
Yes.
And so that's what the sheet says. So Mrs. Delaney, is that
So you're Mrs. Delaney.
I'm sorry.
right? So I miss,
Mrs. Delaney, you're right.
okay, so it's right on your sheet, okay?
But I'm Mr. Phillips, not the witness.
Right.
See, I said the witness. 'cause I
Oh,
just
okay,
assumed I was
sorry.
the
Oh,
witness.
okay, no, I didn't even hear you. Okay, so it's all, oh, it's right on your sheet. I am Mrs. Delaney.
Mr. Phillips. The court.
Mrs. Delaney.
Mr. Phillips. The court.
Okay, so identify us as we speak, and it does start with Mr. Phillips.
Your Honor, before Mrs. Delaney examines, there has been a question as to the number of peremptory challenges. As a result, I am going to move a little earlier than I expected to. As Your Honor has noticed, there are 2 defendants in this matter. It is the expectation of the people that Defendant Matthew Rayburn will testify for the people. As a result, the people move for dismissal of the case against Matthew Rayburn.
Is there any objection, Mrs. Delaney?
No, Your Honor, no objection. May we approach the bench, Your Honor?
All right. Do you want the reporter?
Yes, Your Honor. Since, Your Honor, the people have moved to dismiss the information as against the defendant Rayburn, I move for a dismissal as to the defendant Proctor on both counts of the conspiracy, since there must be at least 2 or more people in a conspiracy. A man cannot conspire against himself, and therefore I move for dismissal of the information on Proctor on that ground.
I thought I had brought that case to court with me, and I see I haven't. The cases show I have no authority at the present time, but you can try one of the conspirators as long as you prove that they conspired with other people.
There are some cases where you can try one, if the court please, yes, but it still takes 2 to make a conspiracy, and there is no charge pending now as against Rayburn. Rayburn is free to go.
There is an allegation in the amended information that they conspired. It is just merely removes him as a defendant in the lawsuit. The allegation remains the same.
I renew the motion. If the court please submit it.
I haven't dismissed it yet, you know.
I know, Your Honor. I said I submitted it, Your Honor, on the motion.
If I understand the law, if you had an acquittal of 1 and you don't allege 2, then of necessity the allegation must follow. But the allegations show that he conspired with both Ellingham and Rayburn.
It says right here, Your Honor, if 2 or more persons conspire.
I have tried a case before against 1 conspirator.
I didn't hear you.
I have tried a case of 1 conspiracy before where the other 2 had already pled guilty.
Just because you tried one before, counsel, doesn't mean that it is the law.
That doesn't mean anything. Well, do you want some time to look it up or what?
I will submit it. I would like to get a couple of cases myself.
I think I can find a case quite soon.
Your Honor, may we have 10 or 15 minutes?
Well, let us see what he has there first.
Very well.
We are having a tough enough time getting started as it is.
The People versus Ortiz. The state of the offense shows that 2 or more persons conspire together to commit the crime, even though only 1 person is indicated.
That is only in relation to the pleading, though.
Well, that is all we have here now, is with relation to the pleading. Ellingham is also mentioned as a co-conspirator, and he is not even a co-defendant.
This is true, Your Honor.
The amendments in the back of the section would seem to be pertinent.
You say they do or they don't?
They don't seem to add anything.
My reaction to it is that you can dismiss and go ahead and proceed. If you want some time to look it up further,
Shall we proceed with the voir dire at this time? In other words, what is the position of Mr. Phillips?
Well, that is the trouble.
The court hasn't ruled on the people's motion. Is that correct, Your Honor?
I haven't ruled yet.
We could take until 2:45, Your Honor.
You are a little better at research than I am. It depends on the court's pleasure. I will do whatever the court wants.
Well, I don't want to dismiss it if it is going to stop your lawsuit.
Well, I think that I haven't read this case. I only read
And then we have your 140 multi number 2, and it says no proper names. Monica, any questions?
No.
Okay, and so it starts in the middle with question by Mr. Pine. Always Mr. Pine's witness unless you have the court speaking to the witness or Mr. Pine.
Choose Mr. Brown.
Okay, you can see us okay, Monica, all 3 of us?
Yes.
Okay. So I am Mr. Pine,
the witness,
The court,
Mr. Pine,
the witness,
the court,
and this is going to be 140 multi number 2 final for 5 minutes. Starts with Mr. Pine, myself asking the witness questions. Without the paperwork or anything else?
I'm not sure. I don't know the exact process of it.
I mean, you were pretty mad because he hadn't turned down his radio. Is that correct?
Yes, sir.
Did he give you permission to come into the apartment and turn down the radio yourself?
No, sir.
But you did it anyway?
Yes, sir. I couldn't even hear. It was so loud that you couldn't even hear what was going on.
And did you get a look at the knife that he used the first time?
Just that he had one. I didn't see, the particulars of it. I had a gash in my face and was bleeding, so it was pretty apparent that it was. He was holding on to it when I was kicking him, and I assumed it was the same one.
So you did see it in his hand prior to him using it against you.
No, sir. No, sir.
The first time you knew there was a knife is when you felt the slash.
Uh-huh. Well, actually, probably a couple of seconds after that.
I think you said a puncture and then a slash on your neck.
Yes, sir. A couple of seconds after that. It bled a whole lot. I don't think it kind of felt like I got punched. And I remember the first thing that I noticed it bled a whole lot. My whole shirt was covered in it, and that's kind of when I knew I had gotten stabbed.
This is the mark on your
Yes, sir.
left cheek?
This one right there.
Yeah. Let the record reflect that there's about 1.25 inches crescent-shaped scarring on the jawline, left side of the complaining witness's face. Was there a mark also from the throat?
Yes, sir. It was real raised, but it's gone away. This has been quite a while. He hit me this way and then came back across my neck. The detective said that he came pretty close to cutting my neck, that I barely missed it. It was a real large welt that came across like this, about 2 to 3 inches. I think they have a picture of it. They took a picture of it.
Did you ever see that knife?
Again, I'd have to say that I'm assuming. When I hit his head and he fell out the door, he was still holding the knife in his hand. And, it was pretty consistent with...
So the answer to that question would be you saw it at a later time in his hand.
A couple seconds later, yes, sir, after I had knocked him out the door.
Would you describe it to the judge as best you could?
Just that it was a knife.
I guess by describing it, could you? How long would you say it was from the bottom of the handle to the tip of the blade?
From what I saw, he was holding it in his hand. He was laying on his right side, so it was in... God, I don't even know what hand it was in. It was just, I remember seeing it, and I remember thinking he's still holding on to a knife. And it, 4, 5, 6 inches maybe in length.
Are you talking about the overall length or the blade length?
The blade length. It was, the blade was, it caught my attention. Or in between where the sidewalk weaves out, there's another complex that I'm in. There's 2 triplexes, and he was in that triplex. It's not really well lighted, but he had a knife in his hand. The house lights are on, and I didn't want him to, get up and stab me with it again, so I kicked it, and then I kicked at him.
Do you know what kind of knife we're talking about here? A folding knife or?
No, like a kitchen knife.
A kitchen knife?
Yes, sir.
You said later that after he lost control of that and he got back up and he...
Yeah, I kicked him.
Okay, so that concludes our 140s. We'll go on to the 120s. Monica, any questions?
No, I'm going to leave the meeting.
Okay, Monica, good
Okay,
luck.
thanks. Bye.
So we have on your 120 multi, number 1, you have Chips versus the City of La Roche. Chips, State of Oregon, Mr. Glees, Janelle Chips, Dawson versus Strongwell. Mr. Jones, Mr. and Mrs. Jones, Joneses. Joneses. Jackson versus Millington, Millington, Jackson. Bodwell versus Oregon, Bedwell. And so it's all colloquy, so you identify us as we speak. I am Mr. Williams.
The witness?
Mr. Smith.
No, I'm not.
I'm Mr. Capstein.
Mr. Williams.
Mr. Capstein?
Mr. Smith.
And this is going to be 120 multi. It does start with myself, Mr. Williams. Number 1 final, and identify us as we speak for 5 minutes. Oh, sorry. I didn't know. Sorry. Here we go, 120. That's all right. We'll research that.
In Chips versus the City of La Roche,
But Chips was running a business, his cows. It was a business matter.
he couldn't see his cows.
He won because his cows were a business investment. His ability to run his business depended on whether he could see his cows, view their activity.
Okay,
That's why he won versus the state of Oregon. Mr. Glees is not running a business.
it makes no difference.
Sure it does. If you were going to cite a case, why did you pick one that clearly differentiates between a businessman and a private owner, such as your client?
I thought you were going to review the case.
We are going to do that.
Well, when you do that, you'll notice in the analysis that nothing is differentiated between what is a business investment and what is a private matter.
We will pay close attention.
In Chips versus the City of La Roche, Janelle Chips lost $4,500 off the mean value of her home when an unsightly fence was constructed by the city around an adjacent power plant.
It would seem this would have nothing to do with our case here. 2 private property owners.
Believe me, it does. But in case you have any doubts, look up Dawson versus Strongwell. Strongwell tries to strong-arm Dawson.
An unsightly fence?
It makes no difference whether a fence, an orchard, or a grove of trees. A private property operations, I would advise him that this case is going to bring a lot of publicity around Mr. Glees and himself.
You know what I think? I think you talk a good game, but when push comes to shove, you won't be there to support Mr. Glees.
I'll be there. You go to Mr. Jones and tell him this. Tell him he's through kicking people around. You tell him he pushed my client into cutting his trees down, and a jury will see that. I guarantee it. The big guy versus the little guy. The bully on the block. That is definitely how the community will see it.
I will tell him.
You tell him we are anxious to settle, but for the $5,000 mentioned. My client wishes to compensate Mr. and Mrs. Jones for the loss of their trees, but he feels he owes him nothing more considering the non-negotiable attitude of the Joneses, and in particular their indifference to his suffering and his particular unique situation.
Here we go. Jackson versus Millington. Millington was awarded damages when Jackson cut down his peach trees.
Because Millington's peach trees were growing over Jackson's fence and property line. Millington wouldn't cut the branches back, so Jackson cut the trees down.
And Millington was awarded damages.
Nor was he allowed to let his trees grow over Jackson's fence and property line,
But he was allowed to regrow.
set back from the fence. Also, the case had nothing to do with someone's ocean view.
Then maybe we're going to set a precedent here.
Not with Jackson versus Millington.
Certainly not with Chips versus LaRoche or Bodwell versus Oregon.
Bedwell, you guys better do some research.
Get ready for the battle of your life.
Research? You want to know about research? Do you know what I've been doing all night and all day until the early morning? I'll tell you. I've got law students volunteering their time to help this man here. That's what. All my case references check out in triplicate. I feel entirely confident you will suffer a melt.
Okay, and we'll get ready for your 120 seconds. You have Kurt Lawson, District Attorney's Office, Mrs. Blair, Mrs. Delaney, and Mr. Phillips. And so it's all colloquy once again. And so identify us as we speak. I am Mr. Phillips.
The witness,
The court,
Mr. Phillips.
the witness,
the court.
And so just identify us as we speak, okay? So, oh, sorry, Michelle. You have the court, all of the banks. You have, is it the witness? The witness, W answer bank, and then whatever symbol used for Mr. Phillips. This is going to be 120, number 2 multi for 5 minutes final exam. Starts with the court.
Let the record show that these proceedings are taking place in chambers with the defendants present.
Okay. At this time, Your Honor, concerning the testimony of Kurt Lawson from the District Attorney's Office, we would like to enter into a stipulation with the defendants that he will testify as to the conversations he had with Mrs. Blair. And this only concerns testimony with Mrs. Blair. These conversations are up to the point where Mrs. Delaney and I agreed that the video recordings themselves should be played, and that would be approximately 5 p.m. on the afternoon of December 3, 1983, after about an hour's interrogation during that afternoon.
Please proceed.
And we have agreed that while playing the videotapes, that if Mrs. Delaney has some objection to the portions that are coming in as coercive or induced by threats or promises, that at that time we will stop the videotape and approach the bench in order for the court to arrive at a determination as to whether the statement is legally voluntary or involuntary. If the court rules that it is legally voluntary, or it is a question of fact for the jury to decide whether it is voluntary or involuntary, we will then resume playing the tape. If at any time the court rules that the statement is legally voluntary, then at that time we will cease playing or viewing any conversations of Mrs. Blair's.
Well, now I understand that this method of handling the tapes is in lieu of my listening to the videotapes ahead of time out of the presence of the jury
That is correct, Your Honor.
and making a ruling prior to the time that they are played in open court. Is that correct?
That is correct.
Is that agreeable with you, Mrs. Blair?
I think so.
Well, don't say you think so. Is it or is it not?
I was trying to think.
What the court is saying, what I have already discussed with you about this, is this. We have a right to have the court pass on the admissibility of this conversation. What the court will do when we make an objection and he feels it is not legally coercion, then it is a question of fact for the jury. Then he will inform the jury and they will take that into consideration in listening to the tapes. It is a matter of saving time, and I feel it is the best way because I would like for the jury to hear the tapes also.
Could I ask Mr. Phillips a question, please?
Yes.
According to these arrangements, how much of the videotape will be played? Will any portion of it be played if he rules that it is coercion?
No,
The same amount will be played that would be played if I heard it out of the presence of the jury, if that answers your question.
That answers my question.
She can't tell you how I am going to rule, and I can't tell you how I am going to rule because I haven't seen it yet.
could we have Mr. Blair?
First, let's get through with Mrs. Blair. Is that satisfactory with you?
Yes, sir.
And you waive your right to have the matter first heard and determined by me out of the presence of the jury?
Yes.
All right.
There is a question of, it hasn't come up until now. I haven't been able to find any law on it. However, I will raise the question. I am sure the court will. Okay, y'all, so that concludes your finals. Make sure you get them all typed up, turned in before the deadline, which is Wednesday at midnight. And have a great day and register on time for your classes, okay?